Okay, it is 2 p.m. and this is the meeting of the Rules Committee of the Superior Court. Attorney Del Campo, if you could engage your camera, and could just the members of the Rules Committee engage their cameras so we can have you on screen, in addition to Attorney Del Campo. Attorney Del Campo, would you do us the favor of doing the roll call so we can make sure we know which members of the committee are in attendance?
Yes, Your Honor. Justice McDonald is here. Judge Chaplin? You're muted, Your Honor. Judge Farley?
Here.
Judge Hernandez?
Here.
Judge McLaughlin?
Here.
Judge Nguyen O'Dowd?
Here.
Judge Pearson? I believe he cannot be here. Judge Prats?
Present.
Judge Stewart?
Okay, I can't see everyone, so if a member, I can see certain members of the committee, I can't see everyone. If a member of the committee wants to speak up, just raise your virtual hand, and I should be able to see that, I hope. If not, just burst in and we will figure this out. The first item on the agenda is the approval of the minutes from the September 12th meeting of the Rules Committee. Is there a motion for approval of the minutes?
So moved.
So moved, Judge Farley.
It's been moved by Judge Farley and seconded by Judge Prats.
Yes.
Is there any discussion, amendments, or changes to the committee minutes? If not, all in favor say aye.
Aye.
Opposed say no. That passes unanimously. And I should again just mention for anybody else who is in attendance, I think I have a list of everybody who wants to participate in each item on the agenda. So please don't engage your camera or your audio until I've asked you to join the meeting. The next item on our agenda is the 2021-023, the proposal to amend practice book section 7-10 and 7-11 regarding retention and destruction of summary process records. I have a report, but just for the edification of members of the committee, Joe, is there any additional developments that we need to be aware of?
Let me see, Your Honor. This was on several times, as you know. The last time it was on was September, and it was decided at that point to that Justice McDonald would meet with Judge Carroll to determine whether or not this could be handled by him as the CCA in some administrative fashion. So Justice McDonald is going to report on that portion of it.
Thank you. Yes, you know, if you recall, we discussed the fact that this was a subject of some work at the Legislative Office Building last year. The Housing Committee had adopted a piece of legislation dealing with this subject. It's unclear why it didn't go any further than just the committee's approval. It did not get taken up in either the House or the Senate. As we all know, that doesn't mean there's a absence of support for a proposal. It just may mean there's an absence of time to discuss it. But I did, as we discussed last month, I did meet with Chief Court Administrator Carroll and Judge Bizzuto, along with Attorney Del Campo, since our last meeting, and asked if this was something that the administration would be able to undertake without any participation of the Rules Committee in the issue. And it was the opinion of the Chief Court Administrator and Judge Bizzuto that they would firmly prefer to defer to the legislature on this subject, particularly since they have weighed in before. There's going to be a new General Assembly beginning in January. We don't necessarily know yet who would be the co-chairs of the Housing Committee, and they asked that we take no action on this item until such time as they have been able to talk with the new chairs of the Housing Committee once the new General Assembly is convened in January. So, having said that, is there a motion to table this until, why don't we say, at least February, so that we can at least track the item, and then revisit it once the new legislative session has begun. Is there such a motion?
So moved.
That was Judge Chaplin. Is there a second?
I'll second Judge Pratt's.
Seconded by Judge Pratt's, with an admirable assist by Judge Stewart. So all in favor, say aye.
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 Say no. That passes unanimously. The next item on the agenda is, and before I go on to that, Attorney Del Campo, maybe you and I should talk about that at the beginning of January, so that we can make sure that the Housing Committee is focused on the issue.
Oh, yes, Your Honor.
The next item is 2022-006, a proposal concerning Rule 2.11 of the Code of Judicial Conduct. I understand that Judge Prescott is joining us. If he could engage his camera and audio, there it is. It's nice to see you.
I am here, thank you.
I think we had this on last month and you were otherwise engaged in other activities that prevented your joining us. So we put it off because we would certainly like to have your background and context for this proposal.
Sure, nice to see everyone. So this proposal was developed as part of a number of experiences that members of my court and perhaps the Supreme Court have had regarding attempts to disqualify us from certain proceedings. And we thought that it would be wise to amend the appellate rules to reflect the manner in which our courts hope to deal with these questions, because our procedures are different than Superior Court procedures. And so we thought that the rules should reflect some of those differences. So probably the best way to explain it is to give you a little bit of the background of a particular case that I was involved in to kind of demonstrate what we see as the problem and why we think we need a coordinate Superior Court rule change at the same time we amend the appellate rules. So I was on a panel hearing a matter in a dissolution case, and the defendant in the case lost the appeal. We ruled in the defendant's favor, and after we issued our decision rejecting his appeal, he filed a motion to disqualify me from the case. Now, we'd already decided the case, but what happened next was he filed a motion for reconsideration. In the meantime, I get a letter from the Judicial Review Council indicating that he had filed a JRC complaint against me. And that letter says, if the complainant is still a party in the proceeding before you, please review Code of Judicial Conduct Rule 2.11(5)(e) regarding the steps that should be taken by a judge upon becoming aware that a complainant has been filed against him or her. So I dutifully looked at the rules, which include both Rule 2.11, canon of the Judicial Conduct, and Practice Book Section 1-22. And there's a certain lack of clarity among those provisions, but what it became clear to me was that I probably, under the circumstances, needed to hold a hearing on the motion to disqualification. But the appellate court doesn't really do that. I mean, we hold oral arguments on the merits of a case very, very occasionally, and probably more so in the appellate court. We have what's called the court's own motions practice, where we'll hear short arguments, but we don't really do hearings, and we certainly don't do evidentiary hearings. But Rule 1.1-22 and Rule 2.11 seem read in conjunction together would require the appellate court to hold a hearing under these circumstances. So I complied with the rule. I referred the matter to Judge Elgo on my court, who held a hearing on whether I should be disqualified. and she subsequently ruled that I should not be disqualified from the case, but it did slow resolution down of the appeal down by several months. And the substance of the complaint, of the judicial review complaint, was simply that I had ruled against him and not in his favor. There were no other claims of judicial bias, really. There was no claim other than the fact that I had participated on a panel in a case in which he had lost. So what we have done here is try to draft an appellate rule, a new appellate rule, section 66-9, which we of course are not asking you to vote on, but we think that for purposes of clarity, that Code of Judicial Conduct Rule 2.11 should be amended, and I presume that you have the proposed amendment in front of you, but it's specifically subsection E of that section would make two changes, really. One which probably affects both Superior Court judges, and one that affects just appellate court judges and Supreme Court justices. And let me just kind of clarify what I mean by that. So right now, practice book section, Code of Judicial Conduct Rule 2.11 says that when a judge becomes aware that a lawsuit or complaint has been filed against him or her, the judge shall, on the record, disclose that fact to the lawyers and parties to the proceedings before such judge. That part of the rule presented problems for us from an appellate standpoint because we're not really on the record. We're rarely in the courtroom, so not really sure what that meant as it applies to us. And we also thought, look, one of the litigants to the proceeding has filed a complaint or a lawsuit against us. The burden should be on the litigant and not the court to disclose the existence of the lawsuit or the complaint. So that, as you can see from the proposal, the first part of that of the changes, the amendments reflect changing that. And if you look at 2-11 in conjunction with Practice Book Rule 1-22, in subsection B of that provision, you'll see that that rule places upon the burden upon the litigant. I'm sorry, I have it backwards. That section obligates the attorney or the party who appears before the judicial authority to advise the judicial authority and other attorneys and parties to proceeding on the record that there is such a complaint. So there's a little bit of a disconnect between 1-22 and Rule 2.11, and so we're hoping to fix that. The other thing you'll see we did in this proposal is we reference Practice Book 66-9, which would be the new appellate rule, so that when an appellate court jurist or Supreme Court justice gets one of these letters from judicial review, refers to this practice book provision, he or she is informed that they can proceed in handling the motion for disqualification or the disqualification issue pursuant to 66-9 and not necessarily 1-22. Does anyone have any questions about that?
I do.
Okay.
What does the proposal in 66-9 actually say?
Okay. Oh, you don't have that?
We do not.
Okay. I'll read you I'll read you the relevant portion of it, which is it's a new.
I'm sorry, we do. I apologize. Okay. We do have it.
All right. So it's subsection C, which is the applicable section to the issue before the Rules Committee this morning, and it basically says that when we get a lawsuit or complaint filed against us, the duty is on the attorney or party to advise the court and the other attorneys and parties to the matter about the existence of the lawsuit or complaint, and thereafter the justice or judge who is the subject of the disqualification issue shall either decide whether to disqualify themselves from acting the matter or refer it to another justice or judge for a decision. It does not require us to hold a hearing. It doesn't prevent us from holding a hearing, but it doesn't require it as Rule 1-22 would seem to do.
And has your committee approved this language yet?
We have not formally adopted it because we're waiting for the Superior Court Rules Committee to operate first, but the advisory committee to the appellate rules has indicated that unanimously that they are in agreement with the substance of the proposed rule.
I mean, I obviously am wearing two hats here. I would want to have a conversation with you about the proposed rule, but we don't need to do that here. I can do that offline with you as an appellate judge, but it does seem to me that before we, on this committee, adopt a change to Rule 2.11, we should have a final clarity about what actually is being approved, and then we would go second. Maybe I'm wrong. Maybe I'm not thinking this through correctly, but it seems like as a chicken and an egg matter. The appellate rules should be changed, and then we conform to those rules rather than we approving something that hasn't yet been approved by the appellate rules committee, if that makes sense.
When Justice Doria, who's the co-chair of the appellate rules committee, and I'm the other co-chair, discussed it, and I think we had a prior conversation with you, Justice McDonald, that we thought that the rules committee should go first, and then the appellate rules committee should go second. But again, subsection C, and I think you have it in front of you, there is unanimous agreement of the advisory committee to make this change.
I will confess, I remember that a conversation was had. I don't remember the substance of it, so I may be inconsistent. It wouldn't be the first time. Attorney Del Campo.
I think, Your Honor, with all due respect, I think that the issue here is that 2.11 is the Code of Judicial Conduct, which the Superior Court judges will vote on. So that's why it's before the Superior Court Rules Committee. So they need 2.11 to be amended to, well, they can't put 66.9 in 2.11 until 2.11 is amended. Right, Your Honor?
Yeah, so what I hear you saying, Attorney Del Campo, is that you think the Superior Court needs to go first, and then we can act accordingly.
Well, it certainly doesn't need to go first for the 66.9, but 66.9 relates to 2.11, which is in the jurisdiction of the Superior Court to change.
Right.
I think.
Right. Adopting 66-9 really doesn't do the appellate or the Supreme Court any benefit until and unless 1-22 and 2.11 are, well, 2.11 is amended.
Okay, let me open this up to other members of the committee first for any additional thoughts or comments about it. Anybody have any input? Judge Farley.
Yeah, it is a chicken and egg thing, because we can't adopt a rule that references a non-existent appellate rule. But I'm wondering about the appellate rules process, because, even if we approve this, obviously it's not going to be acted upon until next June. What would happen between now and then with the appellate rules?
Sure. So we work on a very similar timetable, maybe slightly behind the Superior Court Rules Committee. So we tend to have 2 meetings a year. The Advisory Committee on the Appellate Rules. One in October, we have one coming up in a week or so, and then a spring meeting. At the end of the spring meeting, all of the year's rule change proposals are sent to the judges of the Appellate Court and the justices of the Supreme Court, and they typically vote on the recommendations of the Advisory Committee in late June, early July.
Anything further, Judge Farley?
No, but, I can understand the conundrum for us is we'd be revising Rule 2.11 to refer to a rule that doesn't exist. Whereas if the appellate rules went first, I don't see any impediment is there to adopting the new 66-9 and whether we act on 2.11 now or not. Is that right?
Judge Prescott, let me ask you a question. If maybe we could resolve the chicken and an egg problem by just playing around with effective dates. If the rule change for 66-9 takes effect first, and then we have a effective date just slightly after that, would that work?
I think that would work. I think that if our rule change became effective October 1, that's a little bit tight for publication purposes, but I think it could be made to work because typically, and correct me if I'm wrong, Justice McDonald, but typically most Superior Court rules adopted by the judges at the June annual meeting are effective January 1, unless the vote is otherwise to have them more effective more immediately.
Subject to being corrected by Attorney Del Campo, I think that's correct.
That's correct, Your Honor.
So if you folks adopted the proposal to 2.11 effective January 1, 2023, then by the time that rule comes into effect, 66-9 can be effective, October 1 of that year, of the prior year.
Okay. So in any event, nothing is going to necessarily happen. I would prefer if, now that I understand the problem, if we pass this for a month so that I can talk to you and Justice Doria about the substance of 66-9, we would put this back on so people can chew on that for the next month, and then we can take it up at next month's meeting. Is that okay with everyone? Okay, not hearing any objection. Judge Farley, could you lower your virtual hand so that if you have to put it up again, I know it's a new one. Judge Prescott, is that okay with you?
Yep, that's fine.
That's great. I appreciate that. So we'll pass that until November meeting. The next item on our agenda is 2022-009, a small proposal by Judge Abrams to replace the civil portion of the practice book with the Federal Rules of Civil Procedure. And I believe that Judge Abrams is with us, and we are happy to have him here and would love to hear the background. My joking aside, in one of the communications I received from Judge Abrams, if I recall correctly, he indicated that this type of process has been adopted by many states across the country. So it's not so unusual as I perceived it to be when I first heard about it. Judge Abrams.
Thank you, Justice McDonald. In my view, the proposal is really based on an access to justice issue. And it doesn't so much spring from my affection for the federal rules of civil procedure, but rather from my antipathy for the Connecticut civil rules of procedure. The civil portion of the practice book, in my opinion, is an incoherent mess, daunting even for judges and lawyers, not to mention self-represented individuals. It's like an old house that's been added on to numerous times over many years without the benefit of a master plan. Another benefit of adopting the federal rules that even the most obscure provision has been the subject of numerous interpretive court decisions which can help provide guidance to practitioners, litigants, and judges. Currently, as Justice McDonald indicated, 35 jurisdictions have adopted the federal rules. In the interest of full disclosure, I will say that on a per capita basis, it is far less than half the country. California, New York, it is more the, I made the mistake of doing my own research, and I found a law review article, a fresh look at the federal rules in state courts that unfortunately is 20 years old, and I couldn't find anything. But most of the states, California and New York, have not adopted the federal rules. Now, I realize that this effort is probably quixotic on my part, given where the land of study habits, but the recovering politician in me recalls that, you know, ideas that are abhorrent the first time they come up become, with repetition through sessions, become more and more, tend to be more embraced the more they're brought up. So I'm throwing this on the table, ruining your day, and hoping that you'll give it some consideration, and maybe I'll be in a wheelchair somewhere when they do actually make the, you know, they'll invite me to the ceremony when they adopt the federal rules. So that's all I have to say if you have any questions.
I appreciate that. And I remember the concept of planting a seed to see if it germinates. And I also remember when you were in the legislature, you were the master of doing the uniform laws for Connecticut as they were adopted around the country. So having said that, I mean, can you give me, and we can certainly have this conversation over a longer period of time, but give me a couple of examples where you think that our civil procedure rules are a shambles in relation to some of the federal rules?
I don't know that I've ever, I know we now have proportionality like they do, which is a nice step, but I don't know. I think it's more an idea. It's not so much content as it is accessibility for me. I don't know that I've ever met anyone who successfully used, I can use props, successfully used the index. It's impossible to find anything in here. I mean, I've been dealing with this thing for 40
Fair
years.
enough. Fair enough.
It is, and that really is it. More than, I mean, the content, I don't really have all that many specific issues, but getting to where you can find it is impossible. I mean, it's like we've learned a language. I haven't learned it perfectly. I still have trouble. But anyone from the outside, you'll see criminal judges will come over to civil, and it'll take them 6 months to sort of get their feet, because this just isn't, you know, it doesn't, well, anyway.
That's an excellent point. I do agree with that. I don't know that it's a rules problem. It may be a editing problem. It may be, we don't have anything to do with the index, to my knowledge.
And I may have defamed some poor person somewhere.
No, I do think that a lot of effort could and probably should be put into really working on a comprehensive index that is helpful. I would fully acknowledge our index is not helpful to somebody who's trying to look something up. But let me open it up to members of the committee. Judge Stewart.
Okay, so first I'll mention that Judge Pearson is on a voyage on the high seas, which I believe that language is still in the practice book or something to that effect in the discovery section for depositions. But and he wanted me to convey that he's adamantly opposed. With that out of the way, when I was practicing, first of all, I'll concede that I probably was in federal court more than I was in superior court. There's something to be said for the simplicity. Sorry, my light keeps going off. The simplicity of the federal rules, even though they too have gotten cluttered up over the years. But there's a lot of stuff in the practice book that just doesn't even get used anymore. But the biggest question I have for you, Judge Abrams, is there's also a lot of stuff in the practice book, like the whole, a lot of the family stuff and juvenile stuff that has no counterpart in federal court. And then there's a lot of stuff in the practice book that is interwoven with statutes, like subpoenas, what have you.
Right.
And what would we do about that if we did this wholesale?
I'm only talking about I'm only talking about the civil portion of it.
Okay. All right. So if we did this, there would be some standalone rules still for criminal, family and juvenile.
I presume there would be.
Okay. And how would we go about, I mean, there are, as you know, many practitioners in state court who have never been in federal court and who will no doubt freak out. And there are also, many people who got very upset about, New York lawyers invading our turf, so to speak. Though I think there would be a lot of pushback from the bar. Having said that, I think it's worth giving this committee giving some serious thought to it.
Let me just, probably the first of many additional wrinkles in addition to the one that Judge Stewart just identified. And I may need an assist from Attorney Del Campo here, but there is a very weird wrinkle in our statutes that says that we can't change any practice book rule that deviates from any of the rules that existed before, I think, 1957. Sometime in the 1950s, without the approval of the legislature. And so I think that if we would be going down this way and this road in a serious way, it would not just be a project for us, but it would be a project for the legislature as well. Can you flesh that out for me a little bit more, Attorney Del Campo? Did I get the year roughly correct?
You got the year exactly correct, but I think what it says, 5114, it talks about statutes in effect 1957 or before. If you make a rule that supersedes, modifies, or suspends such a statute, then you have to report that to the General Assembly, basically to give them a swipe at coming back and saying, hey, what did you do? Or not recognizing the rule or whatever they want to do. But never have you not gone about your business over all these years. We do make a report to them every year. It's up to, our office in conjunction with the Chief Justice has to make the report to determine whether or not any of the rules that you adopt or the judges adopt offend those statutes. And it's quite a long, involved process. There was attempts to remove that. It hasn't been removed just yet. I know Melissa Farley's office has proposed removing that as kind of sort of obsolete at this point. But yes, there is such a statute. We do make a report every year. There is the possibility that the legislature could come in and say, hey, why did you do this? And it affects the statute.
So rather than extending this conversation right now, I think this is a launching point. But you have ceded control of the tiller for the civil division to Judge Bellis.
Yes, I have.
Have you talked to her about this at all?
No, I have not. And I made clear, I just want to point out in my letter, I make clear that it's me as an individual Superior Court judge, I did write it when I was still Chief Administrative Judge.
No, you didn't.
And I do want to make clear that it's not my first time at the rodeo. I wasn't expecting a yes vote today. And this is going to take a whole group of people. It may result in a revamping of the practice book, which would make me probably even happier than an adoption of the federal rules.
So,
but it's
so rather than, we would normally take a proposal like this and populate it to stakeholders and see where people were at. But if subject to the input of other members of the committee, I would recommend that we invert that and we ask you, and I'm not trying to pawn it off on you, but
no.
To test the waters among stakeholders to find out if there's any appetite among the bar, among trial lawyers, defense lawyers, if there's any appetite for us to, because I don't want to waste a lot of time for this committee if everybody says it's dead in the water. But if there's a spark, then we can begin a process.
All right, and I'm happy to do it. And I'm going to take. I think I'm going senior, so it may be a slow approach. Don't put me on next month's agenda, please. But I'll take this on as sort of a long-term project. And I'm not interested in wasting everybody's time. But
Judge Stewart,
I think it is important to have the dialogue.
Judge Stewart, you're muted.
I'm usually the one telling people that they're muted. All right. So one other question that I just throw out that perhaps Judge Abrams, when he's testing the waters, could throw out is whether there would be receptivity to taking certain sections of the practice, maybe not the whole shebang, but like summary judgment rules or the discovery rules or whatever, and wholesale adopting the federal rules. I mean, the federal rules are ahead of us usually on the discovery stuff, particularly when it comes to electronic records. Things of that nature. I mean, of course, if we want to ditch request to revise, this could be a stealth way of doing it. Because nobody files a motion for more definite statement in federal court. But anyway, that's a possible alternative that wouldn't be as massive an undertaking, but would be helpful.
I'll also float the index issue.
Yeah.
Yeah, the index is bad.
Okay. So I'm going to leave this in your court, Judge Abrams. And when you think it's ready for us to receive a report from you about the status of your efforts, you'll let us know, I take it, right?
That sounds good.
Always good to see you, Judge.
All right. Nice seeing everybody. Take care. Thank you.
Next is item 2022-011, proposal to amend the practice book to eliminate the requirement for original printed deposition transcripts and to permit service of civil complaints by consent. Is Judge Bellis with us?
I don't believe she is, Your Honor.
Okay. Would you report on this, Attorney Del Campo? I think this needs a statutory change of some sort.
Yes, Your Honor. This is two proposals actually submitted by Attorney Goodbaum. Attorney Goodbaum was invited today. He is here if you have questions of him. But basically, the proposals were two. The first one was to a rule change regarding service of civil complaints by consent. And that was the one that it was suspected that major statutory revisions would be necessary. I did ask Attorney Noble from my office to do that research. She has done that. You have that in your files. It does look like statutory amendments for that to be instituted are required. The second one was to change or to eliminate the need for original printed depositions under Section 13-30E of the practice book. Attorney Goodbaum had suggested that be removed. Judge Bellis did go out to her presiding judges and the civil judges, and there is support for that, although some did still want the ability to request an original transcript for use at trial. Attorney Goodbaum is here if you have questions of him.
Thank you, and I do see him. It's good to see you, Attorney Goodbaum.
Thank you, Justice McDonald.
Would you care to address the committee?
I think Attorney DeCampo has accurately conveyed the substance of my proposals. And both of these proposals were summarized in editorials published by the editorial board of the Connecticut Law Tribune, of which I am honored to serve. The editorial board publishes as a body, so the editorials themselves are confidential, but you can sort of read between the lines from my presence that these are issues about which I am particularly, I don't know, can you be passionate about something this detailed and procedural? I suppose you all would not be members of this committee if the answer were no. So thank you for your service. I'm happy to answer questions. I agree with the analysis from Attorney DeCampo's office. I think there would need to be a statutory change to allow for service by consent. I tend to think that involving all stakeholders in the process of legislative change is an easier one than me, for example, writing to my own state representative and asking for a change about the way that lawsuits get served. So if this committee is persuaded, and I hope it will be, that this is a good idea, that lawyers should be able to serve complaints by email to opposing counsel whom they already know, rather than retaining a marshal to have it served on some, agent for service and then have it passed along through a series of different communications, that the committee might express that to its contacts in the legislature if that's appropriate, and think about that. The adoption of the federal rules would solve that problem. Rule 4 allows for service for waiver of service of process, though it does not allow for waiver of service by email. I have suggested that to the Federal Rules Committee, and they're currently considering that proposal. So we'll see what they do with Rule 4. I'm getting a little far afield. In any event, I welcome questions about the two proposals if you have any.
So I am going to pick up on what I left off with Judge Abrams. I would encourage you to first reach out to the Connecticut Bar Association to find out if they would be interested in supporting this proposal before the legislature. Given my time there, I can assure you that there would be a lot of keen interest by the State Marshals Association in addressing this issue. And I think we certainly have a role in it, but the legislature definitely has maybe not a primary role, but at least a co-equal role in the process with us. And I frankly don't want to waste our time if it's not going to go anywhere. And so I would also want to know what Judge Bellis's position is on this. But really, again, we're going to have to wait until we have the new legislature in January. I'm guessing that the co-chairs are going to stay the same for the Judiciary Committee, but I don't know that. But I think you need to figure out a strategy to approach the legislature first and then report back to us whether there's any interest in the legislature. Does anybody disagree with that suggestion? Okay, does that sound acceptable to you, Attorney Goodbaum?
Of course, Justice McDonald. I'm a member of the House of Delegates of the Bar Association, and so I can pull the appropriate strings and see if there's any interest from the leadership. This is a relatively minor procedural point, but I'll try to drum up excitement about it from my colleagues in the Bar Association.
Thank you, Judge Chaplin.
I want to address the issue regarding the transcript and when it is appropriate time.
Go ahead.
So I guess one question I do have, and I'm not seeing the proposal, was whether there's been communication with the court reporter's office or the judicial branch to know whether there is appropriate technology to watermark the transcripts electronically so there can be some indication. I'm not sure if that would require acquiring a new technology for that or if the existing technology would cover that issue.
I don't know the answer to that. Does anybody?
We could send it internally, Your Honor, if you want to do that to the deputy director in charge of the transcript services. If you'd like to do that, we have not sent it to him.
Judge McLaughlin just appeared on my screen. Do you have anything to add?
No, I was just going to say the most I've seen, right, has just been they have a stamp that says original over the first page, but I don't think it watermarks the remainder of the pages. So other than the grandiose presentation of ripping open the envelope and showing us that it's the original transcript, I don't recall seeing anything electronically that would indicate that, other than, as I said, that front page. And I've never understood. Candidly, I would be in support of something like that. Certainly, I want to hear about from the monitors, but at least from practice of recent days, certainly it seems to me that more often than not, the parties are providing copies that are not the original at trial for a variety of reasons. And I've never run across a problem with it, although I can foresee in certain situations where you may run afoul of that, but that's just my sort of two thoughts on my recent experiences at trial.
I'll just note that when I dealt with that issue was in, oh, sorry.
No, go ahead.
It was in the habeas context, and we know in the habeas context there are so many pages of transcripts that are submitted, and I allow the parties to submit them electronically, but knowing that they were submitted electronically, they were not be able to really claim as the originals because they're electronic. And so there was something with judicial branch logo or something on there for the parties to have some assurances that they haven't been tampered with or something like that. I mean, PDFs really address the issue, but I don't know if the attorneys would want more assurances. And so maybe the reporter's office could give us some insight into how to address that efficiently.
I saw Judge Stewart and then Judge Prats.
Well, the reality on the ground is for the last 2 years, a lot of these proceedings have been remote. And all of the evidence, as I understand it, for appellate purposes, that what they get is all electronic. So, and I don't think people are all, I'm certain in my cases, they're not all scanning in quote unquote original deposition transcripts that they got from some private court reporter during a deposition. It's just all electronic. So this is one of those things where I think the reality on the ground is past where the rule is.
Judge Prats?
Regarding the service, I just thinking that on the family side, this is being done, and especially during COVID, there was a lot of waiver of service on starting an action, like in a divorce complaint, and it's worked really well on the papers where people don't even go to court and the judge reviews everything and signed it. So I'm hoping that with that being done in family court, that there should be at least some model for civil, that could be used, especially for self-represented parties. It's an expense that they don't have to incur. I think that's a really good thing.
Anything further? If not, I guess I would ask Attorney Del Campo to see if he could find out about the watermark issue from the court reporters, and then we will, on the statutory change issues, we'll wait for further feedback from Attorney Goodbaum. Does that sound okay?
Yes, sir.
Okay. Judge Prats, could you lower your virtual hand? Okay, thank you. Then the next item on our agenda is 2022-013, proposal to amend practice book section 2-79D to change the way past due fee notices are sent to attorneys from certified mail to first class mail and email. I believe Chris Blanchard and Kathleen Harrington are with us. If you could turn on your cameras. But first I would turn it over to Attorney Del Campo to tee this up.
Yes, thank you, Your Honor. This was received in August from, on behalf of the Client Security Fund from Attorney Blanchard. It was on the agenda in September. It was put over because I think the committee had some questions of exactly how many notices go out, how do they go out, what the manner of mail is or communication is, and asked that I invite attorneys Harrington and Blanchard to the next meeting so that this could all be asked and answered. So both attorneys are here today to answer your questions.
I appreciate their attendance. I don't know if the two of you have talked about who's going to lead us out on this, but I will hand it over to the two of you.
Okay, Judge, if I may, perhaps, I can just tell you that really the impetus for this proposal came out of the adoption of Practice Book Section 2-27B, which created an enforcement mechanism for, I guess you'd call them, a couple of the administrative annual requirements imposed on members of the bar, the annual registration requirement and MCLE. And under that enforcement mechanism, attorneys are sent notices by first-class mail and by email. They're sent, I think, notices on 2 occasions prior to, and if they don't respond or they don't comply with whichever requirement, whether it's the registration requirement or the MCLE requirement, their license to practice law is administratively suspended until such time as they are in compliance with those requirements. And it's essentially very similar to the enforcement mechanism that's used for the annual Client Security Fund fee, the only difference being that under Practice Book Section 2-79, the Client Security Fund Committee is required to send those notices by certified mail, which is an extremely expensive method of trying to obtain compliance for a $75 fee. Looking at what we did last year for the 2021 fee, for example, there were 10,000 initial past due fee notices sent to attorneys. Those are sent out at, I think, roughly $8 a certified letter. And once those notices are not responded to, there's a second wave of notices that go out by certified mail. So it's a similar enforcement scheme, but the only difference is that the Client Security Fund fee enforcement requires certified mail to be used. So the proposal would be that to enforce the Client Security Fund fee, we use the same mechanism essentially that was adopted in Practice Book 2-27B for MCLE and the attorney registration requirement.
Sorry, I appreciate that. Attorney Harrington, did you have any other context? Or I think Attorney Blanchard covered it pretty well.
He did, Your Honor. The only thing I would mention is that I do have attorneys Elizabeth Rowe and Michael Bowler also online from Statewide Grievance Committee to answer any questions you may have about how the last year's enforcement using the notice by email and regular mail has gone for that new practice book section, if you would like to hear from them.
Would members of the committee like to hear that report? I'm seeing some yeses. So Attorney Bowler?
I think it would be Liz Rowe, I think, is prepared.
Okay. Good afternoon.
Good afternoon.
Tell us your experience.
Well, we're in the middle of implementing this for the first time, so we don't have the best data for you just yet on how we're doing with it. But in terms of our compliance in 2020 and 2021, in 2020, 31,000 lawyers approximately had done their registration that year out of 43,000 lawyers. In 2021, 30,000 out of 43,000. This year we've had 33,000, so we've had a substantial number of attorneys comply. And so how the process works is in January, we send notice to every attorney through e-services to their email address that registration is open and it closes the first Friday in March. During the registration process, we will send a second email reminding people that registration is closing soon and they want to get that done before the first Friday in March. Thereafter, we have sent one email reminder to people telling them registration closed, they missed the deadline, and they need to do their registration if they want to remain in good standing. This year, we added another component, which was we sent a letter around Memorial Day. And that letter went to everyone who was out of compliance saying, you're out of compliance, and if you do not register by the end of the year, you will be administratively suspended. We've looked at this somewhat as a census of the bar. It's been a long time since we've ever cleaned up the rolls of attorneys, and there are attorneys who have never registered. There are attorneys who haven't registered with us for 10 years or 15 or 20 years. So this administrative suspension will be large this year, and it's gathering people we don't have good contact information for. So what happened next was we then heard from we also sent that letter to Pro Hoc Vice attorneys. And we had a number of Pro Hoc Vice attorneys who had never deactivated their status after the case was over. So it helped us clean up those roles as well. And so we're still in the process. We're sending the email this month saying you have 60 days. And by December 31st, if you haven't registered, we'll be sending you a letter. We'll be sending your information to the court, and the court will be administratively suspending you. And that's where we are right now with the process. So we have had about 3,000 more attorneys register this year than have in the prior 2 years. So I think it's been effective in that sense. The other issue that we have seen, and I know Attorney Blanchard has seen as well, is because we're relying on attorneys to give us current contact information. If they have not done prior registrations, we send letters to bad addresses. So we have 3 bankers boxes full of letters that came back to us, but that we notified attorneys that they had not registered and that they could be administratively suspended. They have not received that letter because they didn't provide us with a current office address to mail it to. And the Client Security Fund, I believe, has very similar issues as well. And so once we lose track of somebody, which is why we wanted to create this enforcement mechanism for registration, it makes it very difficult for the Client Security Fund and for us to communicate with attorneys at the bar.
Thank you. Are there any questions from members of the committee? I personally don't see any impediment with moving forward right now, but if folks do, let me know. It seems like a fairly straightforward proposal. Is there any reason we shouldn't move forward? Why don't we do it that way? Okay. Seeing nothing, is there a motion to approve this item?
So moved, Judge Farley.
Is there a second?
I will second Judge Pratt's.
Thank you. Is there any discussion from members of the committee? If not, all in favor, say aye.
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 Opposed, say no. That passes unanimously. I appreciate all of your attendance today to help us through this item.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
The next item is 2022-014, a proposal for a new practice book rule that establishes the procedure applicable to motions for post-termination visitation. And I don't know if Judge Westbrook is with us. As you will recall, we had this on our agenda last month, and I begged for 1 month to just look at the proposal in greater detail. And not surprisingly, at least from my viewpoint, Judge Westbrook nailed it. And it is everything that I would have wanted in the rule. So I didn't know if anybody had any other questions that developed since our last meeting for Judge Westbrook. Judge Wayne O'Dowd.
I just had one question, Justice McDonald, on subsection D, where it says the moving party shall have the burden of proof. Was it in the working group? Was it discussed as to the burden of proof being by preponderance of the evidence or clear and convincing evidence? I mean, I reread the decision again. I'm not sure. I mean, I know where the statutory authority is, where the court is gleaming the necessary and appropriate to secure the welfare protection, proper care and suitable support of the child. That's in the subsection 46 and not the TPR section 17A.
Since the Supreme Court decision didn't address the standard, we're silent on that in the rule proposal.
And I would be, we didn't, I would be hesitant to establish in a rule what a burden of proof would be. You know, you got to keep us appellate judges in business to have future cases. I wouldn't want to usurp the authority of the appellate court or the rest of my colleagues on the Supreme Court by injecting a burden at this stage. Do you agree, Judge Westbrook?
Absolutely. That's why it's silent, because it was discussed. Yeah. What is the standard? But in deference to that, you know, we weren't given a standard. There's no standard put in the proposed rule.
Anything further or about that, Judge Wynn O'Dowd?
No, I'll go for the next appeal, I guess.
Anything further for Judge Westbrook? If not, is there a motion to approve this item?
So moved.
So moved.
It's been moved by Judge Chaplin, and I'm sorry, I didn't catch the second.
Judge McLaughlin.
Judge McLaughlin, thank you. Is there any discussion? Seeing no discussion, all in favor say aye.
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 Opposed say no. That passes unanimously.
Thank you for your consideration.
Thank you for your work. Next is 2022-017. It's a proposal from the Freedom of Information Commission. My understanding is that Colleen Murphy from the Freedom of Information Commission could not join us today and has asked us to mark this over until next month. Is that right, Attorney Del Campo?
Yes, Your Honor.
Okay. And then the final item we have is 2022-018, proposal to conform various rules to various public acts. I think this is kind of a cleanup proposal from Attorney Del Campo's shop, so I'll turn it over to him.
Yes, Your Honor. This is pretty straightforward. We typically, the Office of the Reporter of Judicial Decisions does have the ability to make these changes editorially. This one was a little out of the ordinary, so I wanted you to see it. I don't suggest that the full bench of judges needs to adopt this. I think it is a technical amendment. It's basically one-for-one changing workers' compensation or commissioner out for administrative law judge, which the statute does. It's just that it's a new type of quote-unquote judge, so I wanted you to see it and not be surprised by it. It's changing in a couple of forms and in a couple of locations in the practice book, but I do think it's a technical amendment that we will put forth to the Office of the Reporter of Judicial Decisions, and it won't go to public hearing or to the judges for a vote, if it's okay.
Forgive my ignorance. What did the legislature just make a name change and without a change in responsibilities or duties for workers' compensation commissioners?
I believe so, Your Honor. Attorney Petrozelli's on the call too. She did write up a memo for us on this. She can address that.
You know, the funny thing is, in our court, we presume that the legislature pays attention to everything we do. They should make the same presumption that we know everything they're doing, but I did not. So, Attorney Petrozelli, anything else we need to know?
Hi, Your Honor. No, I believe you're correct. It was basically a substitution of terminology that the legislature did, and actually they did it in 2021, so it's already, kind of a fait accompli, and the forms of the Workers' Compensation Commission have already been changed, and they're already available to the public with the terminology of administrative law judge already there, so we're just looking to conform the language to what is already happening, the current state of affairs.
Okay. I don't think it requires any action on our part, as Attorney Del Campo has said. Sounds like it's just for our understanding. Are there any questions, though, before we proceed? Okay. All right. So I appreciate you bringing that to our attention. You'll take care of that administratively. If there's nothing else for the committee, I will accept a motion to adjourn.
Don't move, Judge Prats.
Is there a second? I'm going to take Judge Chafflin's smile as a second. All in favor, say aye.
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 Opposed, say no. That passes unanimously. Thanks, everybody. I appreciate your time.
Thank you.